Can I just say something about Andrea?
Hey everybody, welcome back. We are just a few minutes from court getting started over there in Provo. I'm on the WebEx link this time, and Judge Graf just literally just wrapped up his last hearing. It makes me feel even sorrier for this guy with the workload that he has and stuff like that. I know he mentioned before he's got like 1,300 cases on his docket or something like that. So anyway, I just finished listening to whatever case was going on before. It seemed like some kind of grandma request, and it involved something about a search warrant being executed at a Salt Lake City police officer's house. I don't know. He seemed less than captivated. But so we're waiting for the ruling, and we got two things, of course, on the table for today. Is the preliminary hearing going to go forward on the 18th? And are we going to get cameras in the courtroom? So I put up a poll on the continuance part. I can't run two polls, or I would, but I'll just tell you guys my predictions right now. I think that both of the motions are being denied. He's not going to continue the preliminary hearing, and he's not going to ban the cameras. That's my prediction. We'll see. But I have a little bit of a reason behind that as far as the preliminary hearing goes. And it's because I've been doing a little bit of digging into Utah procedure and kind of the history of how they do preliminary hearings there and stuff. And so I can show you maybe a little more of this. Well, I'll just pull this up. And you can see what I'm looking at. So this is the part of the Utah Constitution that provides for the rights of the defense in a criminal case. And it's this language down here at the bottom that involves a preliminary hearing. And so when it says where the defendant is otherwise entitled to a preliminary examination, the function of that examination is limited to determining whether probable cause exists unless otherwise provided by statute. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule in whole or in part at any preliminary examination to determine probable cause or at any pretrial proceeding with respect to release of the defendant if appropriate discovery is allowed as defined by statute or rule. So I did a little bit of investigation into this particular provision, and I found out some interesting stuff, which is that this highlighted part of the Constitution was only adopted in 1994, and it was adopted in concert with all of the Victims' Rights Act. This was kind of what was going on in the 90s all over the country, and Utah was no exception. And so before 1994 and this amendment, the preliminary hearing was much broader. It had like literally part of the purpose of it was to use it as a discovery tool. And so what that meant is that it ended up being kind of a little mini trial, that the defense attorneys could use it like as kind of like a deposition. You could call all of the witnesses and investigate lots of stuff that didn't necessarily have to do specifically with probable cause. You could be investigating credibility issues. You could be investigating suppression issues. Just much, much, much broader scope than the narrow question of, are we justified in moving forward with this prosecution? And so the reason why they did that amendment is because essentially of the burden, the impact that kind of process has on crime victims. And like is often the case, a lot of this, or at least a lot of this, the discussion around it revolves around victims of sex crimes. It's probably the most extreme situation that people are kind of able to understand and relate to. Why that would not be a lot of fun to have to get up on a stand and testify and be challenged and so forth, not just one time, but twice. And so that was a big part of the motivation for streamlining and limiting the preliminary exam. So it's no longer this discovery type of tool. It is bare bones, just focused on probable cause. And that now kind of puts in context for me. We heard at the last hearing some of the discussion and conversation about some of the case law that involved, like, does the defense have the right to subpoena a victim to appear at the preliminary hearing? And we learned no, you have to get permission of the court to subpoena a victim, and there has to be a showing that the victim's testimony would be reasonably likely to defeat probable cause. And so it's a little bit of a I don't want to say peculiar situation, but it's just they have a right, the defense has a right to call witnesses and present evidence at the preliminary hearing, but they don't necessarily have the right to compel people to appear. So the way that it's kind of set up now, if they got voluntary witnesses, they can call them and they can present their testimony. But if they're going to use the power of the court to try to compel somebody who isn't volunteering to show up to testify, then they have to go through the court and get permission and all of that. I'm just going to take us over to the over to the WebEx so I don't miss it when it gets started. So anyway, I was going through that background, and so that was the big concern, was the impact to victims. And just the streamlining, more efficiency. It's obviously going to take a lot more time and a lot more just effort and stuff like that if you're having a broader scope hearing than if you're having one that's narrower scope. Even back then, they were dealing with courtroom congestion and things like that. So anything that they could do to kind of make that a little bit more manageable, while at the same time kind of preserving the basic function of what this hearing is supposed to be, which is to identify cases that never should have been brought. It's kind of the bottom line. It's not a very high bar. So where am I going with all this? That's the context for that these guys are familiar with. This is the history and the situation that they're aware of when it comes to what the preliminary examination is about, why it is limited the way that it is. And so they have this weighing of kind of the narrow focus of what the preliminary hearing is at this point in time. The fact that the reason it's so narrow is victim rights focused. And then the fact that Erica, has invoked her right to a speedy trial. Utah gives her the right to do that. So I think all of those things in concert are kind of creating a bit of a situation where they need to justify the delay, and they need to justify it in light of the extremely limited purpose of the preliminary examination. And so I don't think that's going to happen. The argument that they have made has been largely, based on wanting to do additional discovery and things like that. And I certainly understand and sympathize with that. But it did not look to me like the law was really on their side in that respect. The state had pointed to some of the discovery statutes that set timelines for things to be produced. Says pretty specifically that expert discovery doesn't have to be completed before the preliminary hearing. And that was, really what the defense request had been based on, was the DNA and the ATF and FBI ballistics tool mark, things like that. Not even like the reports, but all of the underlying data and stuff. And so because that is going more to that discovery function that the preliminary hearing used to be about, but isn't anymore, I don't think that's going to give them cause to kick it down the road. So that's my prediction, but very eager to see. Now on the cameras, I don't even have a lot of doubt that we're gonna have the cameras. I really don't. Judge Graf has just been so receptive and open to the idea that transparency is really essential to avoid the misinformation and so forth in the case. It's just the best remedy for that type of problem. High profile cases are tough. I mean, there's just no question about it. There's always issues and implications when it comes to the prospective jury pool. But that is not really caused by there being cameras in the courtroom. That's just caused by the fact that this was a very high profile person who was murdered in a very visible, very public way. This was very upsetting, to a lot of people. And so, of course, there's a lot of interest in it, and people would be talking about it even if we didn't have the cameras in the courtroom. And so, just given the very favorable attitude that the Utah courts have under their rules towards the cameras in the courtroom, and the kind of philosophy that Judge Graf seems to have, at least so far, articulated about the case, it seems unlikely to me that the cameras are going to be yoinked. However, there is a little bit of a wrinkle in that, which is the pending motion for sanctions, a motion for an order to show cause and for sanctions that the defense has filed against the prosecuting attorneys. They took issue with Mr. Ballard responding in the press to claims that were being published mostly by the Daily Mail, but repeated by other outlets, that the ATF report showed that the bullet that they recovered from Charlie's autopsy did not match the rifle. And, it was a big front page, like 3-inch headline in the Daily Mail. And so that's an extremely misleading way of presenting what the ATF actually concluded, which was that there's not enough information to be able to say, yes, it came from this gun. They could say we can't exclude it, like we can't prove that it did not come from this gun, but not enough to be able to say no other gun in the universe could have fired this particular bullet. So Mr. Ballard had made some comments to the press where he said, basically, generally speaking, here's what an inconclusive result means. And they think they have sufficient evidence to overcome his presumption of innocence. And I think that was largely it. So that has now been fully briefed. The defense filed their reply just yesterday. And so that is up on the archive now. Maybe we'll go through it at the end, because I think this is likely to be a pretty short hearing. Most people are here in the room. We are just waiting for the judge and everyone to get started. So that will probably be within minutes. Looks like yes is winning the poll. Yes is winning the poll. People think it's going to be continued. I'm interested. Why do you think so, guys? Why do you think it's going to be continued? I hope this isn't just, pessimism. Oh, hey, am I frozen? Oh, no. Okay. I hope I'm not. Yeah, I am frozen a little bit. Oh, well, I guess it happens sometimes. Poor Judge Graf, he really did probably have to go like pound a little coffee after this last hearing. I mean, I like court. I usually find court really interesting, and even I, for like the 20 minutes I listened to it, was like, good Lord, this is painful. This is painfully boring. But and the judge can't show any of that either. You know, it's a boring civil case to the people that are professional in the court dealing with cases all the time. But to the parties, to the litigants, their case is the most important thing in their lives. And so you can't show how boring and uninteresting their problem is. But that can be a challenge sometimes. Seems like everything gets continued. I mean, that's fair. That's fair. What else? Any other? Pessimism. Yeah. Because that's how my Friday is going. Okay, we've got, I would say no, and if it's continued, that would be ridiculous. I mean, I do. I understand the defense's perspective. I really do. It's just that they're coming from a perspective that is a little more 10,000 foot process-wise. Mr. Novak is the guy who practices in like really all over the country, primarily in California. Mr. Burt also primarily in California, but a lot in federal court. And so it's a different system and a different kind of set of priorities and stuff like that. So I think they're translating that mindset into Idaho, and it just doesn't quite fit, because Utah. Have I said Idaho this whole time? Oh Lord. Utah's process is just a lot more narrow than they might otherwise want it to be.
Good afternoon. Court is now in session. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Ryan McBride, Chad Grunander, Jeff Gray, Chris Ballard, David Sturgill, Lauren Hunt for the state.
Good afternoon.
Michael Burt, Richard Novak, and Stacy Visser for Mr. Robinson.
Good afternoon to you.
Good afternoon.
Jeff Hunt and Carissa Erisk for the news media, Your Honor.
Good afternoon. And Mr. Robinson, are you with us? Let's try again. Mr. Robinson, are you joining us this afternoon? Good afternoon to you, Mr. Robinson. All right, before the court issues its rulings, the court is wishing for an update on the status of discovery to the state.
Yes, Your Honor. We continue to receive and provide discovery. The materials that were brought up at the last hearing, the DNA files, the ATF DNA files have been transferred. I think the defense is making their way through those. We provided much of those in digital format through an online sharing process. That wasn't workable, so we provided a jump drive with those materials from the ATF. We consistently hit the 100% mark where we provided everything that we have received, and material continues to come in, so we continue to provide that. So that's the status of discovery. FBI is still responding to the special discovery request. I expect to have that response within the next couple of weeks. They asked for some time when I spoke to them about 3 weeks ago. So we expect to have that response quickly as well.
Thank you. Defense, did you want the benefit of the record?
Special discovery matters that Mr. McBride was just referring to were the DNA files from the FBI. I just want to make sure we clarify that for your honor. And also, I think we just received 1,600 files either today or yesterday, I believe today. And that's all.
Thank you. All right, prior to the court's rulings on the two issues before it today, the court acknowledges the quality of the briefing and the professionalism and civility during the presentation of evidence and during the oral arguments. The court has taken the necessary time to consider the evidence before it and balancing the constitutional rights of Mr. Robinson and Ms. Kirk. These rulings take into consideration these important constitutional rights. I will begin with the ruling in order on defendant's motion to vacate or continue preliminary hearing pending discovery and to permit constitutionally adequate time for preparation. And I will be reading from my order and will be uploading the written orders very soon after this hearing concludes. Per the state's request during December 11th, 2025 hearing, the court scheduled a preliminary hearing for May 18th and 19th and 21st and 2026, but noted that the date was not set in stone and could be moved if needed. Defendant now seeks to continue the scheduled preliminary hearing via his motion to vacate or continue preliminary hearing pending discovery. For the following reasons, the court determines that a continuance is both reasonable and necessary to safeguard defendant's procedural rights while ensuring the orderly and fair administration of these proceedings with due consideration for the interests of the victim representative, the parties, and the public. The purpose of a preliminary hearing is for the prosecution to present evidence from which the court may find probable cause to believe the crimes charged have been committed and the defendant committed it. And I'm going to omit the citations, but that will be in the written ruling. A preliminary hearing serves the essential purpose of ferreting out groundless and improvident prosecutions early in the process. Indeed, the preliminary hearing is a fundamental procedural right guaranteed by Article 1, Section 13 of the Utah Constitution. The decision to continue a preliminary hearing rests within the sound discretion of the trial court. Generally, a continuance is considered reasonable when there is a showing of good cause and the request is made for legitimate reasons. The court notes that the May preliminary hearing dates, which allotted some 5 months between the scheduling of the prelim and the hearing itself, was set as a goalpost for the parties and to preserve time on the court's calendar. This is defendant's first request for a continuance, and given the volume of discovery, the request is neither unexpected or unreasonable. At the time the present motion was filed, the digital electronic discovery had reached 12 terabytes. The defense counsel estimated they would need at least approximately 60 days to conduct initial review and possibly hundreds of hours to conduct a comprehensive review. Substantial discovery continued to be produced as of March of this year. The court recognizes that additional delay imposes real burdens on the parties, the victim representative, and the public's interest in the timely administration of justice. A defendant's constitutional right to effective assistance of counsel is no less important at the preliminary hearing than it is at any other stage. Providing defense counsel sufficient time to review the extensive discovery is necessary to ensure effective representation, and under the circumstances presented here, establishes good cause for a continuance. The scope of a preliminary hearing, however, is admittedly narrow and utilizes the lower evidentiary bar of probable cause as opposed to beyond a reasonable doubt. Furthermore, the court must view all the evidence in light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution for purposes of making the requisite bind-over decision. The preliminary hearing is not the time to weigh credible but conflicting evidence. Accordingly, any future requests for additional delay to obtain further expert analysis, such as DNA testing, must be supported by a particularized showing that the requested analysis is reasonably necessary to the fair resolution of issues, particularly where the existing evidence is sufficient for the limited probable cause determination at issue. The court is also mindful of the impact a delayed trial or delayed hearing may have on the victim representative's constitutional rights. To mitigate this impact, under Utah Code Section 77-38-7 sub 3, directs the court to consider the interests of the victim of a crime to a speedy resolution of the charges under the same standards that governs a defendant's right to a speedy trial. The court remains committed to the victim representative's interest in the speedy disposition of this case, just as it is committed to protecting defendants' constitutional rights and maintaining the fair and impartial administration of justice. The court also concludes that the revised hearing dates reasonably balance defense counsel's need to review the presently disclosed discovery with the victim's representatives in the public's interest in the timely progression of the proceedings. Therefore, the court grants defendant's motion and reschedules the preliminary hearing for July 6th, July 7th, the afternoon of July 8th, July 9th, and July 10th, 2026, in order to protect the defendant's constitutional rights while minimizing unnecessary delay and preserving the fair, prompt, and impartial administration of justice. This is the order of the court. Counsel, that concludes the first ruling of this court. Court now turns to the second issue before it, ruling an order on defendant's motion to exclude still photographers, TV cameras, and microphones from the courtroom, and standing order on electronic media coverage requests. One moment, I need a little bit of water before I start reading the next one.
It's going to be long.
Thank you. Before the court is defendant's motion to exclude still photographers, TV cameras, and microphones from the courtroom. Defendant seeks an order categorically prohibiting any electronic media coverage during the pendency of this case. Because defendant has not shown that a categorical ban on electronic media coverage for all proceedings in this case is allowed by Utah law, defendant's motion is respectfully denied. At defendant's request, the court held an evidentiary hearing where Dr. Brian Edelman, a trial consultant, and Dr. Christine Ruva, a cognitive psychologist, testified in support of defendant's motion. Dr. Edelman conducted a survey of 200 people in Utah County and prepared a report with his assessment of the local community's consumption of media coverage of this case. His base findings reveal that 99% of the community members recognize the case and that 64% believe defendant is guilty based off what they have heard, read, or seen in the media. He examined press coverage of the hearings that have taken place since defendant's initial appearance in court and discovered that only about 25% of the viewers watched the live stream of the court hearings. A majority of the remaining viewers consume media commentary of the live stream recordings over social media and local television news sources. According to his research, the commentary from established news media does not provide a neutral summary of court proceedings. Rather, headlines and talking heads typically focus on out-of-court statements made by attorneys and prominent members of the community and country. As a result, viewers are led to believe that the comments made out of court, such as the comments about unadmitted evidence, are made during a court hearing and part of the criminal case. According to Dr. Edelman, this commentary primarily supports the prosecution's narrative and is used as entertainment, sensationalism, and commercialization rather than to educate the public on what is occurring during the court proceedings. Dr. Edelman also expressed concerns that media coverage of the security measures used during the court proceedings, combined with cameras in the courtroom, will be added pressure on the potential jury pool and contribute to potential jurors' reluctance to serve on a future jury. During cross-examination, Dr. Edelman testified that viewers who watch the live stream, usually on social media and streaming sites, are inundated with commentary from other viewers spreading misinformation. Although the commentary is being made by the public, it is not generated by the live stream itself. In his view, the commentary would not exist without the live stream of court proceedings. Dr. Edelman's opinion is that continued media coverage, electronic media coverage of court proceedings will perpetuate prejudicial and misleading views of the defendant and the evidence and affect defendants' fair trial rights. Dr. Ruva testified that she specializes in the study of jury decision-making, specifically how pretrial publicity affects memory and the deliberative process. Among other concepts, her studies focus on source primacy of pretrial publicity, which indicates that if jurors are front-loaded with the extensive amount of negative pretrial publicity toward a defendant, it is difficult to overcome their initial biases, even if presented with positive publicity about the defendant or negative publicity about an alleged victim. Dr. Ruva examined the pretrial publicity referenced in defendant's motion, which she summarized as provoking moral outrage and predominantly anti-defendant, full of dehumanizing language and accusations of guilt. Dr. Ruva explained that the jurors have a high amount of confidence that the information they use to reach a verdict is based on evidence that was presented at trial. However, research shows that jurors' memories cannot distinguish between what was heard at trial and what was heard from pretrial publicity. Jurors may even unconsciously distort evidence they hear during trial to align it with slanted information they heard pre-trial. Because video and audio sources of pretrial publicity result in more emotional responses, these sources are better remembered than other sources of information. Dr. Ruva's expert opinion is that live streaming of all proceedings can lead to deep-seated bias in juror deliberations. And while juror questionnaires can help eliminate jurors with the explicit biases, they are not effective at identifying implicit biases. Dr. Ruva concluded with her expert opinion that to a reasonable degree of psychological certainty, this case is situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality. Based upon this evidence and an evaluation of the factors listed in Rule 4-401.01 of the Utah Rules of Judicial Administration, defendant argues that exclusion of electronic media is necessary to ensure Mr. Robinson's right to due process, to a fair and impartial jury, to counsel, and to be free from unreasonable searches and seizures, and to be free from cruel and unusual punishment as required by the 4th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 7, 9, 10, 12, and 14 of the Utah Constitution. Members of the media, like members of the public, have constitutional rights to access criminal proceedings. Again, the citations will be in the order that will be filed. I will not read them right now. However, like the public, the news media does not have a constitutional right to photograph or video record public hearings and trials. Once beyond the confines of the courthouse, A news gathering agency may publicize within wide limits what its representatives have heard and seen in the courtroom, but the line is drawn at the courthouse door. Although electronic media coverage is not protected by the Constitution, neither does the Constitution ban electronic media simply because there is a danger that, in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter. Electronic media coverage provides a means to facilitate the public's right of access to court proceedings for those who cannot physically occupy the limited space available in a courtroom. Live streaming in particular allows as many people as are interested to observe the justice system at work and hold our branches of government accountable to the guarantees of due process.
That's right, Judge.
Defendant argues that the decision whether to allow electronic media coverage is governed by Shepard v. Maxwell, which held that there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial. That the court must take remedial measures to abate any threat to the fairness of the proceedings. Defendant argues that because video recording and streaming of court proceedings creates a reasonable likelihood of prejudicing defendant's right to a fair and impartial jury, this court should ban courtrooms for the remainder of the case. This court should ban media in the courtrooms for the remainder of the case. Consistent with Shepard, the court has taken remedial measures to abate threats to the fairness of these proceedings. For example, the court has positioned the video camera to the back of the courtroom, which has minimized, if not entirely mitigated, the potential for media to capture conversations at counsel's tables and documents on counsel's computer screens. The court has issued a robust decorum order to manage the proceedings and a pretrial publicity order to prevent statements from attorneys involved in the case from potentially prejudicing the jury pool. Rule 4-401.01 of the Utah Rules of Judicial Administration governs the court's determination of whether to grant or restrict electronic media coverage. The rule allows a news reporter to file a written request for permission to photograph or video record public proceedings. The rule creates a presumption that the permission will be granted as long as the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public. Defendant argues there is no presumption of electronic media coverage because the predominant purpose of dissemination of the court hearings in this case is not for journalism or the dissemination of news. Rather, it is for entertainment, sensationalism, and the promotion of commercial products. Defendant provided many examples of media outlets using footage of courtroom proceedings as background or as a springboard to discuss out-of-court commentary by public figures, opine on the relevance or existence of evidence that has not been admitted or presented in court, and generally vilify the defendant. The state referenced social media posts that have used media coverage of the case to promote conspiracy theories and to denigrate Charlie Kirk and his family. No evidence was presented by either party showing a media outlet using live media coverage to educate the public about the progress of the legal proceedings or the justice system as a whole. This court is not so cynical as to conclude that just because the parties did not present evidence of responsible journalism, none exists. Defendant did not interrogate the use of the live stream of prior court proceedings by the news reporters who filed the electronic media coverage requests under Rule 4-401.01. Applying the plain language of the rule, it is the motives of these specific news reporters, the requesting reporters, that the court must question, not the entire universe of media outlets and social media sites that have published information or misinformation about this case. Because under Rule 4-401.01 sub 2A, the court must examine the motivations of specific news reporter who request to photograph or record the proceedings. Defendant's request for a blanket finding by this court that there is no presumption of electronic media coverage is respectfully denied. The court must determine whether the presumption applies on a request by request basis, depending on the predominant purpose of the requesting news reporter. Determining whether there is a presumption of media coverage is not the end of the analysis. The judge may prohibit or restrict electronic media coverage in those cases only if the judge finds that the reasons for doing so are sufficiently compelling to outweigh the presumption. The rule then lists 9 factors, some or all of which the court must consider to determine whether to limit electronic media coverage of court proceedings. Defendant argues that because the rules uses the phrase "in those cases," the court has authority to weigh the listed factors and find the presumption of electronic media coverage has been overcome for the pendency of a case, regardless of the type of the proceeding held. Reading the rule as a whole, the court disagrees with the defendant's interpretation. The court interprets the phrase "in those cases" to mean the same thing as "in those situations," where there is a presumption of electronic media coverage. The court's interpretation is consistent with subsections 2C and 2D of the rule. Subsection 2C requires the court to make particularized findings, denying or granting a particular request. And subsection 2D requires that those particularized findings to relate to the specific circumstances of the proceeding rather than reflect generalized views or preferences. Court proceedings vary in character and substance, ranging from scheduling conferences to oral arguments to evidentiary hearings and to the trial itself. The dangers of prejudice and the newsworthiness of the proceeding may vary considerably depending on its nature. Therefore, because the court must make a particularized finding about specific court proceedings that are the subject of a news reporter request, defendant's request for a categorical finding that the presumption of electronic media coverage has been overcome is respectfully denied. The court must make the appropriate findings on a request by request basis. Unless otherwise ordered by the court, Rule 4-401.013A requires news reporters to file an electronic media request at least 1 business day before the court proceeding. 1 business day is insufficient time for the parties to object to electronic media coverage or for the court to weigh the appropriate factors and issue a decision. Therefore, the court enters the following. This is the standing order on electronic media coverage. News reporters are required to file requests for electronic media coverage of court proceedings at least 14 days before the scheduled proceeding. The request must be consistent with all other provisions of Rule 4-401.01. Any request that is filed later than 14 days before the proceeding may be summarily denied. All requests will be filed in the docket. If a party seeks to suspend or restrict electronic media coverage of a court proceeding, the party must file a motion under Rule 4-401.01 no later than 10 days before the proceeding. The motion must address the particular circumstances of the proceeding and be no more than 4 pages in length. The opposing party may respond to the motion no later than 5 days before the proceeding. The response is limited to no more than 4 pages in length. Any reply must be filed no later than 3 days before the hearing. The reply is limited to 3 pages in length. No oral argument on the motion will be held. The court will issue an order before the proceeding, and if the request is denied, issue particularized findings denying the request. The evidence presented at the April 17, 2026 hearing and all arguments already in the record are preserved. This is the order of the court. This concludes the reading of the second ruling of this court. All right, counsel, what I want to turn to next is addressing the outstanding motions. As we are vacating the preliminary hearing, which is set for, I believe it's May 18th,
Yes, it is.
the week of May 18th, that frees up time to address outstanding motions. And the court wishes to make best use of the time as you were previously scheduled to be there. So I'll turn to the parties to hear from you in determining if the parties will be prepared to address the motions that are outstanding. Turning to a defense.
Your Honor, I believe, are you talking about the ones that have been fully briefed at this point?
That's correct, or anticipated to be fully briefed before that week begins.
Yes, Your Honor, we can be prepared to do that.
All right, and to be clear, do you want to put on the record the motions that you wish to address at that hearing, just so all parties are on notice and we know how we're proceeding?
Give me just a minute, Your Honor, and I'll pull them up. I know one of them is the motion for the order to show cause and compel discovery. You know, that one is pending right now. Just 1 minute, let me pull them up.
I'm glad I'm not the only one that's lost track
Kathy,
of
while
what's
you're doing
still
that,
outstanding.
Your Honor, I show 3 outstanding motions. The one is the motion for an order to show cause, a contempt. That is fully briefed. I believe that's ready to be argued. Actually, I think that's a notice to submit without argument is how it's been submitted. The second is motion to close the preliminary hearing and seal exhibits. That was filed May 1st. We intend to use the full 2 weeks to respond. If the defense intends to reply, the reply will be, I believe, the 21st, which will be the day before the current preliminary hearing dates end. So I don't know if they intend to waive that reply time and argue it at that time or not. And then the final one is the recent motion the defense filed to find the use of hearsay at the preliminary hearing unconstitutional. We intend to use the full 2 weeks to respond to that. It also hasn't been served on the Attorney General's office, so that one will not be ready by the time of our preliminary hearing dates. We're going to have to find another date for that. We've also objected to the motion to close the prelim and seal exhibits because our objection is that it's not specific enough. We don't know which exhibits that is. So that issue needs to be resolved too before it can actually, from our view, be argued and decided upon.
All right, thank you, Mr. McBride. Turning to Ms. Nestor.
I do think we were waiting on their supplemental exhibit and witness list, which we have received. I don't know if they're still going to update it again, but that's one of the things we were waiting on before we identified which matters needed to be sealed in the preliminary hearing. So I know we could perhaps get together and talk with the prosecution about whether they anticipate adding any additional exhibits. And then we can probably specify which exhibits we think, but we had to leave it open because we didn't have their final exhibit list until within the last, I think, 2 days. We would be prepared to argue the motion to show cause and the motion to close the preliminary hearing. I do believe we either have, and I would defer to Ms. Visser, I believe we either have served the Attorney General or we are just about to serve the Attorney General, but I do anticipate that one might not be ready to argue by the week of the 18th. That one probably, I would agree, may need an extra date, but it would need to be heard prior to the preliminary hearing because it deals with whether some of the 1102s can be presented at the preliminary hearing.
All right. So my understanding is it sounds like the parties will be ready for defendant's motion in limine to close portions of the prelim. Is that correct?
Yes, Your Honor, and we can supplement with specific exhibits now that we have their final exhibit list, I believe. I'll talk with the prosecution and our team, but I believe we can supplement that.
All right.
Chad Grunetter, I'll add on to that. If it is supplemented, Ms. Nestor, it would probably need to be done rather quickly, as the preliminary hearing dates or the previous dates are a week from Monday. And we would like the time to brief that and be on appropriate notice. I would imagine the media would have similar concerns, but so Judge Graf, I'm not entirely sure if we'll be prepared to argue that motion on the dates that are open for your honor, but we can work towards that.
And may I add, Your Honor, this is Jeff Gray.
Yes, Mr. Gray.
Notice to the Attorney General's office. They may choose or may not choose to respond. They're not required. They're required the particular notice, and we'll be talking with them. If they're satisfied with our response, they may choose to stay out of this at this point, but we still need to consult with them.
I also, Your Honor, just want to make clear, we don't necessarily, we serve the Attorney General out of an abundance of caution, but we do think since it involves a rule of procedure, it may not really be required to serve the Attorney General under the statute, but we did it just out of an abundance of caution. So I don't want to make it look like we're conceding that notice is required, although we are doing it.
I see.
Certainly our position is that it is required.
All right. Well, I appreciate the parties sharing their views. Well, let's go ahead and tentatively address the motion to close the preliminary hearing, and we'll address that. How does May 19th at 10 a.m. look for the parties?
Your Honor, the defense was planning on being available the whole week for the preliminary hearing, so I feel fairly confident that my team is going to be available on that day.
All right. To the state?
Your Honor.
All right. We'll go ahead and start at 9 a.m. on that day. And just to set the expectations, we'll plan on a 3-hour hearing. So from 9 to 12. And so I would ask that you're fully prepared to go forward at 9 a.m. And to Ms. Nestor and your team, is it your request that Mr. Robinson be present physically in court?
Yes, Your Honor.
All right. All right.
Your Honor, this is Jeff Hunt. The media will want to be heard on that motion. I believe Mr. Judd is online, and he will be taking the lead on that. I'm not sure of his availability that day.
All right. Mr. Judge.
Hi, Your Honor. I am here. And yes, I'll make myself available that day. I did, without taking any more of the court's time than is necessary, wanted to talk about one small detail. I appreciate the court's ruling saying that under the new order being entered today, a request to cover a hearing would need to be submitted 14 days in advance. That would only create problems, I think, with the one we're talking about today.
Right.
I wonder about a request to do that. If the media were to submit that as soon as they could get their ducks in a row collectively, would that be enough for the court in this case?
Yes, and I recognized when I was drafting the ruling that the one conflicting date would be this upcoming one. So I would request that the parties file, well, to be fair, until there's a request from the media to cover it, that wouldn't even come into play. Theoretically, if they choose not to file that becomes moot. And so for this hearing only, as soon as that's filed, please file anything that you wish to be considered as soon as possible to allow the other sides to reply. So please don't wait till the day before. If it's filed, I would say within 48 hours of the filing of media, the request for electronic media coverage, within 48 hours, parties who wish to file, please do so. Thank you, Mr. Judd. I appreciate you addressing that. The court's obviously going to be flexible about that issue, given the short turnaround.
Thank you, Your Honor.
Judge Michael Burt for Mr. Robinson. Could I raise one issue concerning the court's order on the procedure going forward? is the court requiring that we be notified of the requests, or do we have to get that from the docket? Given the short amount of time that we'll have to respond, I'm wondering if the court would consider ordering, if it hasn't already done so, that we be provided notice of any requests when it's filed.
Well, wouldn't you be receiving, do you receive notice when the request is filed on the docket?
Only when it's issued by the court, Your Honor. We don't receive notice of the requests.
I see. Well, let's see here. That is a good question, Mr. Burt. I appreciate you asking that. Let me just take a look at what options we may have to address. Well, on the onsets, we have the deadline. I mean, we have given the deadline set by the court. There's a timeline in place, and so I would ask the parties to be cognizant and take a look at the docket on the date when that deadline is approaching. So for now, please refer to the docket. If this becomes an issue, please let the court know. But I would ask the parties to be diligent as you have been in the past. And when you see that hit the docket, if you wish to file, you certainly can.
Thank you.
Yeah, this is Ms. Nestor. I do have one more clarification. So the motion of the order to show cause, can we not just argue that the same day that we argue, just because of the travel and expense to the county? I'd like to try to do that at the same time. We did file a notice to submit, but we've not waived argument on that.
Let's see here. I wanted to pull up that motion briefly. There's a few things on the docket, so it takes just a little bit to get there.
No worries, Your Honor. I don't anticipate there would be any testimony at that. It would just be argument. So we shouldn't need too much more extra time.
All right, I see. One moment. So what you're saying is you're not requesting an evidentiary hearing, you're simply requesting oral argument. Is that my understanding?
That's correct, Your Honor.
Well, I believe that the procedure is that if I rule on the motion and I grant it, we do need to take an evidentiary hearing because sanctions are being requested. And so I would want to follow the procedure. So it would necessitate an evidentiary hearing, not just oral argument.
That would be my understanding. That would be later. So this is just a hearing to determine whether or not to set the evidentiary hearing is my understanding. So yeah, right. So that would be on a later date.
Okay. Well, we can address oral argument for that, and then the court will make its ruling and take it from there. Obviously, I'm not weighing in either direction. I want to consider everything that's before me, but we'll set the oral argument as well on that same 19th date and address that issue as well.
Thank you, Your Honor.
Anything further from the parties?
I don't think so.
All right. Thank you to all parties for being here. This concludes today's hearing, and court is now in recess.
Thank you.
All right. Well, that was, let me get this off here. That was, not shocking. Obviously, I was wrong. He did go ahead and kick it down the road, but what is that, like 5 weeks? It's not a crazy long continuance. And so the justification, I think this comes down to at the last hearing when he asked Mr. Novak, have you guys had time to review the discovery that you've received so far? And then all of the attorneys, came forward to the podium at one point or another to talk about, like, this is what I do in the case, and this is how I've been spending my time, and this is what I haven't had time to do, and so forth. And so I think that's likely what precipitated it. He said it's just based on the need for counsel to have adequate time to function as effective counsel. Based on the volume of discovery, he says it's neither unexpected nor unreasonable. And so based on that, he says he is going to, he's going to continue it so that they have more time to prepare. But he says, given the narrow scope, if they're going to ask for any additional requests, then they have to make a particularized showing about the need for additional evidence. So I'm kind of interpreting this as he's not saying I'm delaying it so that you can get the FBI and the ATF stuff that you've been requesting, which incidentally at the very beginning, he said he asked for the discovery disclosure, the discovery update. And they said that the FBI's DNA files and the ATF files have already now been produced. And so it sounds like what they're still waiting on is the FBI files and underlying data and stuff relating to the tool mark or the firearm, whatever exact testing the FBI did on the bullet, the fragments, the casings, whatever. That still has not been produced, but he says they're expecting that within a couple of weeks. So the judge is not saying, I'm delaying it so that you have time to get those. He's saying, I'm just delaying it because there's a lot of discovery here and a lot for you guys to go through in order to be prepared. And so I think what he is saying with this additional kind of warning here is that if you're going to make a new request to say, oh, well, we still haven't gotten X, or we need to be able to investigate Y or whatever, that for that type of request, he's going to require them to show, here's why it's necessary, likely, here's how it's likely to undermine the probable cause determination and so forth. So it's kind of a compromise, I think. And I mean, it does, to me, it makes some sense. It makes some sense. They did all get up on the stand and be like, yeah, no, of course I haven't been able to review all of the discovery. It's a massive amount. And I mean, yes, I would expect that it is. So giving them a little bit more time to go through that makes a good record just in terms of effectiveness and preparation and so forth. But he's also not kicking it so far down the road that we have a really, really terrible delay. So July 6th through 10th, guys, mark your calendar. That's going to be a busy week. We've got a 250-year America celebration to have. That's gonna be, oh man, that's gonna be a rough Monday. I think a lot of people might be partying through that whole weekend, but not our legal teams probably. So much for your good time, guys. You're gonna be getting ready and getting your sleep. So then the camera ruling, let's be real specific about what this is, because he's not saying I am allowing cameras at every future proceeding. What he's doing is he's saying I am not going to categorically ban cameras from the courtroom, like period, full stop, no cameras allowed. He says Utah law doesn't allow me to do that. What I have to do is I have to consider cameras on a case-by-case basis. If you're going to object to them, there's specific factors that I have to consider, and I have to look at whether the particular entity or person that's making the request is doing so for a journalistic purpose. So it's going to be different, you know, if I, Andrea Burkhart, sent in like a live stream, you know, request, Judge, I'd like to, you know, sit there with my phone and film it or whatever. I mean, I probably couldn't even do that because I couldn't pool. It's going to be a quite different standard than he's going to apply to an established news agency making the kinds of requests that have, you know, typically been made. So he's not saying cameras are absolutely allowed for all future hearings. He's saying I'm not going to ban them. And so if you want them gone, you're going to have to show me for any particular request why that request should be denied. And in the meantime, the media is going to continue to be able to request electronic coverage of the hearings. He modified the process so that they have to submit their request a lot earlier than they've had to do so far. They have to submit it 2 weeks ahead of the hearing, so that the defense can object if they want to, and the judge can consider all of that. But it's going to be based on the Utah rule and the factors that he has to consider. And those are just, you know, things like, well, I mean, we can pull up the rule. I don't necessarily remember it off the top of my head. .4202. Pretty sure. Oh no, that's the classifying. Shoot. I can find it. I know I can. Electronic media coverage of court proceedings. Okay. Here's the factors. Go ahead and pull that up. And is it super tiny? Yes, because of their format. Let's see if I can make this bigger. There we go. There's a presumption, and you have to consider these are the factors that he's talking about. So likelihood that it'll prejudice the rights to a fair proceeding, reasonable likelihood that it will jeopardize safety or well-being of any individual. If it's like a mob trial and you're going to have informants and stuff like that, you know, that's a factor for the judge to consider. Also, you know, he can just modify the process to accommodate those kinds of interests. Reasonable likelihood that it will jeopardize the interests or well-being of a minor. Anytime children have to come in and testify, or we're going to be testifying about children, that can be significant. A reasonable likelihood that it will constitute an unwarranted invasion of personal privacy of any person. This is less likely to be an issue in criminal cases, but in civil cases is kind of generally regarded as less important for the public to, you know, necessarily have a real view into what's going on, and there can be, you know, lots of private issues and things like that. But even in a criminal case, it can involve things like, you know, third-party interests and stuff like that. Whether it will create adverse effects greater than those caused by media coverage without recording or transmitting. So if we have to just rely on what the media tells us, will that be better or worse than seeing for ourselves? Adequacy of the court's physical facilities, the public interest in and newsworthiness of the proceeding, the potentially beneficial effects of allowing public observation of the proceeding, and any other factor affecting the fair administration of justice. So he has to consider those factors anytime the media is making a request and the defense says, I don't think they should be allowed to film this one. And so this has kind of put us in a little bit of an interesting situation, because I do wonder if this is going to become, is it going to bog them down? I mean, if the defense is like committed in principle to the position that categorically cameras are bad in this case, then it kind of seems like on principle, they need to object to every single request for media coverage. They haven't objected to any, like, specifically so far, which I guess is kind of interesting, maybe a little bit contradictory. I don't know. Are they going to need to do that? I mean, if there's potentially, I think, an argument to make here, because what they're trying to do, okay, so they're making their record, right? Everything the defense is doing in this case, at least one of the purposes, if not for some of these issues, the primary purpose is to make the record for the future. Really good example of this motion that they talked about that we're going to be hearing at some point in the future. They're arguing that allowing hearsay to be considered at the preliminary hearing is unconstitutional. Now, they mean federally unconstitutional, because as we just saw in the Utah Constitution itself, which I'll just go ahead and bring up again, the Utah Constitution itself very specifically says nothing in this Constitution shall preclude the use of reliable hearsay evidence. So it is not unconstitutional under Utah law, and there has been some case law that came up in their briefing on this issue that, you know, Utah Supreme Court has looked at it and basically said, like, yeah, this is okay. So we're in a situation where that motion is clearly going to be denied, because Judge Graf has to follow controlling Utah law, and controlling Utah law has said this is allowed. And so what they are doing is looking down the road for, say Tyler is convicted and goes through an appeal process and he doesn't win, and he goes through a post-conviction process and he doesn't win. That's now when he has the opportunity to go into federal court for a habeas corpus type of action. And so these federal constitutional issues, that's really for the federal court to decide. I mean, yes, the state court can decide federal constitutional issues, and they sometimes do. But you always kind of have the option to ask the federal courts to weigh in on that, because they're the ultimate decision maker about the meaning of the federal law and the federal constitution, just like state Supreme Courts are the ultimate authority on the meaning of the state constitution. So they are looking down, like, that far down the road to, like, someday we may end up in federal court and we will have this federal due process type of argument that we need to make, knowing that it's not going to be granted in the short term, but it will be all the way down the road. So this is a big part of what the defense team is doing. I see this motion concerning the cameras as really in that same kind of it's in that same kind of category. The Utah rules are clearly very favorable to cameras. Like, I mean, we've said many times, probably the most favorable in the nation. And it seems pretty clear that the rules themselves say you got to consider this stuff state by state. So your request for a categorical ban isn't going to be granted under Utah law. But they've raised these questions about, you know, does it impact these federal constitutional interests, the right to the fair trial, the due process, and all of that? And so they're looking down the road to potential federal review of this type of issue. The problem is, though, that if they don't, like, now object specifically to every request for cameras. If I'm the prosecution in 20 years and we're sitting in the district court and we're doing a habeas case and they're arguing, hey, that categorical ban on the cameras that I requested, that should have been granted. If I'm the state, the AG or the U.S. attorney that's responding to that, I'd be like, yeah, they waived that when they didn't object to the cameras being present in court. So I think it's very possible that in order to achieve what I think one of their probably primary goals is with bringing this motion in the first place, which is keeping it in their pocket for federal review in the future, they're kind of stuck now that they're going to have to follow through. They're going to have to continue to assert these interests that they're claiming are implicated. So that's going to be a potential bog. It's going to bog them down. Maybe. I'm just trying to think about logistically how this is going to work. Cause okay, so a lot of times with things like this, maybe you just, you create some boilerplate basically, right? Because you're just trying to preserve your rights. He's going to let the cameras in. But at the same time, you do have to object rigorously and specifically enough that you are giving the judge an opportunity now to make the kind of decision that you will 20 years down the road be asking the federal court to review on. Because if you don't, then they can go and say, well, you never raised that. You didn't exhaust it in the trial court. You waived it by not bringing this specific concern. So it puts them in a situation where doing a boilerplate, we're just, objecting to preserve our rights kind of thing, it probably isn't going to be sufficient to get them where they want either. So this might be a little bit of a be careful what you ask for to the defense kind of ruling. I think they might be stuck that if they want this to be a viable issue for future review, they have to object to everything. But we'll see. I guess we'll see. So that was the substance of what the decisions were. As far as the discovery update, kind of briefly touched on that. The state says that the DNA, the FBI's DNA and the ATF files have been transferred to the defendant. Much of it has been in digital format. The FBI is still responding to a special discovery request. I think that has to do with their firearm analysis, which I think is what Ms. Nestor was clarifying. The DNA files that they received are from the FBI, and they received about 1,600 files yesterday or today. Then after the hearing, we went to the outstanding motions because he's kicking the preliminary hearing down the road. Everybody has already put aside the May 18th through the 21st dates. So everybody should theoretically be available. So can we make good use of that time? I knew as soon as he asked Ms. Nestor, would you like to tell us what is still outstanding? She doesn't know. I don't know either. It's chaotic. Okay. This docket is getting to be a little bit nuts. I'll share it over there on the Substack, so you can see kind of where we're at here. We're on to 530 documents right now. This one outstanding. This is the one that we will be addressing, the motion in limine to close portions of the preliminary hearing and seal particular exhibits. This one is not a particularly interesting motion because they just said basically we want to talk about it before the hearing goes forward, but like they described, they were not specific about what they think needs to be shut off from public view. So that's going to have to be specified, and then they'll have an argument about that. I mean, like, what else? The OSC, this is the order to show cause. This is the defense's motion to find that Mr. Ballard is in contempt of the gag order by going to the press and making the statements that he made. That one has now been fully briefed because the defense filed their reply right here. That was just yesterday. So that is now up. And then this, they just filed 2 days ago, that motion about the hearsay evidence potentially being unconstitutional under the federal constitution. So the reason why they said that they were talking about giving notice to the AG is because there's a specific statute in Utah that if you are going to be arguing that some provision of Utah law is unconstitutional, you have to give notice to the AG because they participate in that. So that's what they were talking about. I'm not sure why. I mean, Kathy's saying, like, we gave notice and an abundance of caution, even though we don't think we really have to give notice. I'm not sure why she would think you wouldn't have to give notice, because they do seem to be saying, like, pretty clearly if you apply these things to the preliminary hearing, it would be unconstitutional. And so, I don't know. Maybe she thinks it's an as-applied challenge that's limited and doesn't require notice or something like that. But it would pretty clearly have broad implications because the reasoning for it would not be just limited to Tyler Robinson's case. But yeah, I mean, you can see it doesn't take a whole long of scrolling before you kind of lost. And where are we? I don't know where we are. The supplemental request for discovery was the thing for the communications from the prosecutor's office with the press and so forth. So yeah, this is why it's very difficult to keep track of what's going on and what's outstanding and what's not outstanding. But Mr. McBride was definitely ready. He knew what was going on. So yeah, it's the order to show contempt, that's order to show cause for contempt that's still outstanding. And so they're going to hear that on the May 19th hearing. And then the motion to close the preliminary hearing and seal some of the exhibits, they're going to do that as well. The use of the hearsay at the preliminary hearing being unconstitutional, that one is not going to be ready by the May 18th week. So they're going to have to set a separate date for that. We'll probably get a date for that May 18th. After we have this hearing, they'll get that scheduled, I would guess. So that's kind of where we left it. He did make a special exception on the 14-day. Order is going to come out with a new process that the media has to follow to get the electronic media coverage approved. They have to file their request 14 days before the hearing, but he's making an exception for that for this one on the 18th because we're obviously already past that deadline. And we're only just learning about this new requirement today. So he is going to be flexible about that. Only thing the judge, I got to call out that thing the judge said. I'm like, oh, I feel seen. I feel seen that the judge he's not so cynical to believe that just because neither party showed him examples of responsible journalism, that means there's none out there. And it's true, right? It's the whole point is that the parties don't have our interests at stake. They have their own separate interests at stake. And those of us who want to watch the process and monitor it and learn about what happened and see the evidence for ourselves and judge the process and everything, we may not think highly of how the parties perform, one way or the other. And so it's kind of in all of their interests to, not necessarily be real favorable to us paying attention. But I really like that. He's not so cynical to believe there's no responsible journalism. I appreciate that because, it's easy. It's so easy in this world and in this line of work to get so freaking jaded and so black-pilled. I talk all the time about the ways in which I am black-pilled on court and justice and all that. But I do still try to have some hope for the process, right? I got to have some kind of faith in it, or why on earth are we doing all of this? It's the reason why it's a problem is it's a universal problem when you have principles. We were talking about this yesterday with the Alice Evans case. Is the problem is when you have principles, you're at a disadvantage strategically relative to people that have none. And so people who are happy to break the rules or, do shady shit, they can position themselves in ways that you who are not willing to do that aren't going to be able to compete with. And that is part of the cost of having principles, because it's just the reality that that's how the world operates, that not everybody has them. So, yeah, just because I'm super black-pilled doesn't mean I need to be super cynical about everything. And I feel like this judge is like my spirit animal. I like him so much. Really do. I am not so cynical either to believe that every single piece of journalism is bad. Give my shout out again to Mountaintop Media. I've been giving all the shout outs to Mountaintop Media because they're just one of the great news organizations that when they cover the Mickey Steins case over there in Letcher County, Kentucky, the judge the sheriff who shot the judge. And every time they report on developments in the case, they post the whole legal document. They share the legal document for us. I'm like, yes, this is real MVP kind of stuff. So it's out there. It exists, at least somewhere if you go looking for it. So I loved that particular comment by the judge. He's probably been on the bench and in this line of work longer than I have, and he's still not that cynical. So hey, if he's not that cynical, then I don't have to be either. So I mean, not gonna lie, I was kind of looking forward to the preliminary hearing in a couple weeks, but not to be. But that said, we don't have to wait. We don't have to wait super long. So I'm going to actually count the weeks for myself. Oops. Where are we at here? Yeah, it's already May. So 1, 2, 3, 4, 5, 6, 7, 8. Yeah, it's like 8 weeks. It's like 2 months. So not terrible. And then it sounds also like there is some supplemental either witnesses or exhibits that are going to be filed. So we did get the state's preliminary list of witnesses and exhibits, which I will also, since we got some time, go ahead and pull that up. Where are you at? Here we go. State's witness list is pretty short so far. It's just it's five investigators, and then Lance Twiggs's recorded statement. Not going to be coming in live to testify. He apparently gave a recorded statement. Well, I'll talk a little bit about this in just a minute, because I think there's potentially some interesting stuff there. And then the evidence that they've disclosed so far is drone images, photos, a variety of different videos. We've got video of shooting from behind Charlie, from behind the booth, from behind the questioner, the rifle. The medical examiner report is, for me, like, this is what I'm waiting for. That's pretty much the main thing that I care about, because that is, I think, going to put a lot of it's just going to put a lot of questions to rest. I understand. I know there's a lot of skepticism about the 30-06 and that being feasible as the kind of weapon that could have produced this. And so the medical examiner's report is going to be really critical to that particular question. We've got some other written statements here. C. Noble, I don't know who it is. Mike Mitchell is the retired sheriff deputy from Washington County. So this is the family friend, I presume, the guy that assisted with Tyler's surrender. The video at the Washington County Sheriff's Office. So this is presumably the video of the surrender. I'm assuming this is going to be in the interrogation room where they said he went in and sat for a couple hours until Utah County showed up to pick him up. The recorded statement of Lance, the text messages, the Discord chats, photographs of the note, the rounds from the rifle, photo of a burnt note from the apartment, the targets, the ATF DNA report, FBI DNA report, ballistics, all this other stuff. So a few more things that they did that, I mean, we hadn't previously known about, but we know they did the tool marks examination, but, you know, don't know the specifics about it. The ballistics are a little bit different than the tool marks. The ballistics are typically looking at things like the caliber and the, you know, the angle and stuff like that. And then apparently also some DNA testing that was done on the Dremel and the cartridges. These they don't specify, but I'm assuming the cartridges that they're talking about are the ones that they recovered from Tyler's house, along with the Dremel, which they are identifying or going to presumably be arguing is the tool that was used to do the engravings. So they're going to be looking for Tyler's DNA on those as well. So it's fairly extensive, but of course there are some omissions, some things that, you know, we might expect to see given what was in the probable cause affidavit in the information, but are not on here. The most notable one, of course, is Tyler's parents. And I've seen a lot of people call this out. It's I don't know, one of the kind of points of controversy in the case, the role of Tyler's parents in all of this. And so my interpretation of this, they're not just like presenting hearsay statements. This is very unlike Lance, where they are specifically, you know, going to use this recorded statement. The parents are not identified as witnesses. There's no statements, so they're not going to use them, it looks like, at all, at least at this point. They are instead going to use, I anticipate, the family friend to kind of bring in the story of Tyler's surrender. So we'll have to see how that plays out. Now, okay, so the reason why Tyler or Lance, I think, is maybe in a little bit of a different boat than the parents is because of this. Oops, hang on, let me bring it up. When it says 1102, what it's referring to is this rule. This is the rule that defines what reliable hearsay is in Utah. And so it's not just any hearsay, like any hearsay, you know, my cousin told me X. It's not that. It's a little bit more limited than that. And so they define specifically what it is. So if it would be admissible at trial under the Utah rules of evidence, so things that fall into a hearsay exception, for example, it's you know, it is hearsay, but you're allowed to use it because it's a statement of a party opponent, or it's a present sense impression, or it's an excited utterance. It's kind of these classic hearsay exceptions. They would be able to use that. This is also just, you know, Rule 804 is part of the hearsay exceptions. Evidence establishing the foundation for or the authenticity of any exhibit. This is what they were referring to as well when they talked about, well, actually, I don't, now I'm kind of confusing myself. I don't remember if they talked about it today or if it just came up in one of the documents that got filed recently. Anyway, just because they have like a video, yeah, he mentioned it today because it had to do with the video video from the public. And so they have to authenticate any type of exhibit that they're going to present. And that means there has to be somebody who's able to say, here's what this thing is, and this thing is authentic. This thing is true. It's correct. It's not been modified. It's not been altered. It's in the form it's, supposed to be. And so typically that's going to require, either, preferably it's like the person who took the video. I suppose in theory, you might be able to get there through like a metadata expert or something like that. But it's going to be more of a hurdle. So you really want the person who took the video, but you don't necessarily want to have to haul them, over to court in Utah, some, college kid who's trying to take his finals or whatever. Although I guess now in July they'll be out, but either way, you don't necessarily want to haul them into court just to do that. So they can do a statement to authenticate the video, and then they can use that instead of having to call that witness in. The scientific laboratory or forensic reports. This is all the FBI, ATF stuff, medical autopsy reports. These things are all technically hearsay. But they are going to be allowed in for this hearing. Statement of a non-testifying peace officer to a testifying peace officer. So they don't have to call every single cop who was involved in the investigation. They can call the lead detective, and he can report everything that everybody else told him, even though he doesn't have personal knowledge of it. So he assigned, Officer Smitty over here to go interview somebody, and Officer Smitty went and interviewed him and then wrote a report and gave the report to the detective. The detective can testify about that report under this rule. Statement made by a child victim of abuse. That's not going to be an issue here. Now, this is the one. This is the one that's going to apply to Lance. A statement of a declarant that is written, recorded, or transcribed verbatim, which is under oath or affirmation, meaning sworn under penalty of perjury, or pursuant to a notification to the declarant that a false statement made therein is punishable, meaning you've been warned that if you don't tell us the truth, you can be potentially liable for that. So I kind of have some thoughts about why there's some possibilities. Let's just say this. There's some possibilities about why there might be 1102 testimony from Lance that is being offered and not similar testimony from Tyler's parents. So some of the options are, one, they don't think Tyler's parents are necessary for probable cause. They're going to leave them out of it. This is, it gets under, I've made this comment before, in a few different contexts, but it's not always appreciated how much the family members of a perpetrator suffer. Their life has been ripped out from underneath them, just as much as the victims of the crime, because they have lost the son they thought they had, and so for them to have to be in the position of testifying against their own son, this is an extraordinarily traumatic, devastating thing to have to do. So I could see a universe where the prosecution is like, we don't need them. We don't need to put them through that at this point. And then it's also kind of still there as leverage for trial, that's okay. We cut you a break at the preliminary hearing, Tyler, but if you go forward at trial, your parents are going to have to do this, and they're going to suffer. You're going to be the reason why they have to suffer, because you were demanding a trial and so forth, and they're going to have to get up and do this, and you're going to be responsible for that. Why don't you just plead? Right? It's leverage. So that's one possibility. Certainly a possibility that the parents aren't, they contest maybe some of what's been reported in the information, or they disagree with it, or maybe they've changed their minds, or just whatever. That is possible. If that is the case, the defense can call them. So that's one where I think we can kind of just wait and see how that one unfolds. But here's where I think it's potentially, you know, here's a possibility that I'm kind of maybe leaning towards, which is just basically, I don't think they were ever formally interviewed. The 1102 description that they gave, where it's under penalty of perjury or you've been warned that you can be sanctioned criminally, you know, this is a formal interview setting. So Lance was clearly formally interviewed, or at least offered a statement that he attested to, you know, under penalty of perjury. But it's a video recorded. It's not a written statement. It's a video recorded statement. So this is probably an interview, and I'm just gonna say, I don't know who interviewed him. I don't know. We're gonna find out. I think it's a good chance it was the FBI. And part of the reason I say that is because that's pretty standard when the FBI interviews you. If you lie, you can be charged for that. And they warn you that before you sit down for the interview. So the way that the FBI interview format works is already kind of parallel with these requirements under the Utah rules. Not nearly as common. I mean, I don't know. I don't practice in Utah. I don't know the Utah standard, but just in general in state court, it's not really as common for there to be like available sanctions like that, or even for interviews to necessarily be that formal. You're not required to do it under penalty of perjury. Now they often do. But it's not always going to be part of the built-in part of the process the way that it is so much for the FBI. And so if they're going to do this real formal interview process, it's typically, you know, going to be for witnesses that they need to nail down. Like they need to be sure these witnesses are going to just not going to change their minds, not going to be like feeding them information to lead them astray or whatever. I'm just thinking about cases where these types of things happen. Like it's super common in gang cases. This is one of the reasons why gang cases can be really hard to work. You have the combination of like nobody wanting to talk, but then they will also get these floods of volunteers who are there to provide them false information to point them in wrong directions. And so having to sort through like all of this noise can be a real mess. So that's just been my experience, like with gang investigations, way more common for them to like do it through this formal process and require it to be under penalty of perjury. Tyler's parents, probably not in this situation. And we just kind of know this from the context, because the context here was they had the conversation. As far as we know, they had the conversations with Tyler. They had the conversations with the family friend. The family friend arranged for Tyler to surrender to the Washington County Sheriff's Office. Parents, friend, Tyler go to the sheriff's office, and then family seems like is telling telling them what happened, why they're here, and this is kind of like what the lead up was. So it doesn't sound nearly as much like a formal type of setting. And just in terms of the progression of events, that it's like the first thing that the police learned. It's not necessarily the situation where they would sit them down for a formal interview. They just like take their information and then follow up on it. So that's one possibility that I'm kind of leaning towards, is just that the parents maybe were not formally interviewed and maybe they don't want to participate now. I don't know. I really have no idea. And we're not going to know, unless and until the parents want to tell us, or until we start getting into the evidentiary phases of this process, and they're called to say what they want or whatever. Lance, on the other hand, Lance was formally interviewed. So to whatever extent, like Tyler's family was kind of treated more informally, it does not appear that they gave that type of courtesy to Lance. So we'll see how that plays out. But as soon as I saw that 1102 and kind of what those requirements are, I was like, it reminds me a lot of the FBI interview, because it's a little different about just, you can get in more trouble for lying to the FBI as a general rule than you can for lying to local police. So, what else? What else do we have? That was the witness list. So that's the preliminary. So still possibly waiting on some supplementation. Now, I will say one of the things I was kind of curious about when I got the exhibit list. Let's just pull it back up again. Why not? When I first saw it, one of the questions that I had was that I kind of thought it might be a little bit of a problem. Here it is. Might be a little bit of a problem if they're not calling the parents or the grandparents or whoever. And they had also filed a notice saying, we're not going to use the DNA. The DNA, the FBI or the ATF DNA report with the rifle, at this point, that's their only direct link that they're going to be able to offer between Tyler and this rifle, right? As far as we know. I guess it depends on how good the video is and what exactly you can see on video and stuff. But we don't have like the parents or the grandparents coming in to testify. Yeah, that's the rifle that Tyler's grandfather gifted him. So they're not identifying it to link it with Tyler. Tyler himself is extremely unlikely to testify. He's not going to do it. So how are they going to connect him to it? It's potentially, the DNA. It's not the strongest evidence, but they're going to have to sort that out for trial, not really deal with it at this stage of the preliminary hearing. Because the whole issue with it being potentially a mix and the mix being a complex mixture and the validity of the software that they use to deconvolute it and all of this kind of stuff, which is awaiting us down the road. They had filed a notice. The state said, look, if the issue with the timing of the preliminary hearing is going to be, affected by our using the DNA, the defense not having the DNA discovery, then we'll just not use the DNA. We think we have enough otherwise. I'm not so sure about that. Now, I think that is probably no longer on the table since we've moved the preliminary hearing and the defense now has at least some of the DNA. Not clear, said ATF files have been transferred. Yeah, not clear if the ATF DNA files, if that's what Kathy Nestor was saying, that the DNA files that they got are only the files from the FBI. It's still a bit unclear. Anyway, think that's off the table now, and they'll be able to use this to make that link. But I will admit that when I saw that notice in combination with what was here on this exhibit list, that was kind of one of the thoughts I had was, how are they going to connect this rifle to Tyler if they're not bringing anybody in to testify? This was his rifle, this one that we found in the bushes over here. It was the one his grandfather gave him. Doesn't seem to be anything else like obvious in the in the exhibit list. So it would be a circumstantial case at best, I guess, based on the video. And we already know about some of the contents of the text messages where he talks about, grandpa's rifle and all that. So maybe that would be enough for the low standard of probable cause, but it's just not ideal for their case, right? It's definitely not ideal for their case. So we may get a supplemental. It sounds like, Kathy said they just received it. I'm going to go ahead and look, because why not? Check the docket real quick. See if anything new has popped up since I checked this morning. Stop. I know this case number so well by now. 2514-03576. Anything new? It takes a minute to load because it's such a big case. All right. Okay, no revised exhibit list yet. There are some new documents though, so I will be getting onto those. Of course, we got the rulings that he just issued today, and then the state's objections to closing portions of the preliminary hearing and to find that the use of the hearsay is unconstitutional. So the state has filed some objections to those, and then we have the new orders, but so far, not a supplemental witness or exhibit list. Kathy said they just received it, so maybe that will be forthcoming. So yeah, we'll see. We'll see what, if anything, new is on that. But it sounds like they're not planning on any really significant changes to how they're going to present their case. So we got to wait a little bit longer. Not ideal, but it is what it is, I guess. We have had a few new members. Guys, this is super awesome. Some gifted members. Oh, Hella, you are awesome. Thank you so much for that. And Mindy Ann. Gifted memberships. Thank you so much. Animals Over Human is a new member. You guys are awesome. Love seeing all the green. Go through the chat. Ginger Puff 764. Andrea, the best at analysis. Well, I called the continuance wrong. I'm not gonna hide from not having a perfect record, but maybe that was just me not being sufficiently black-pilled and cynical. No, honestly, the more I think about it, the more I think that was really probably not a wrong decision, because it protects the record from the ineffective assistance for lack of preparation and stuff like that. After everybody got up to the stand at the last hearing and said, I haven't reviewed all the discovery, you're kind of stuck at that point. Now he's not going to let them get away with that indefinitely. That would become a problem if that became an ongoing basis that they raised to justify delay and continuing things and stuff. But just for this purpose, short continuance, one request, substantial amount of discovery. They all said they haven't had time to review it. Really does make a better record against ineffective assistance of counsel claims for him to go ahead and grant that continuance. So that's just maybe me not thinking enough like a judge, which is fine. I'm not a judge. Lucy Fair, dearest Andrea, your lesson on biased versus informed opinions has made me excruciatingly aware of how many people, even lawyers, get it wrong. All. Yeah. I don't know how rigorous this particular distinction is. I find it to be quite helpful. It's a mental construct that works for me. You know, bias, the whole point of it is that it's resistant to information. That's what makes it a bias. Like when you're a racist, for example, it's like because you've already formed this general conclusion, this categorization or whatever, and so you're not going to take into account individual characteristics. You're not going to judge things on an individual basis. You're not going to be receptive to that new information. You're going to apply your preconceived bias to everybody in this class that you're dealing with. So that's kind of the core of what bias is about for me. But having opinions, exercising judgment using our prefrontal cortices, that is just a thing that human beings do. Like that is what we do constantly. That is what makes us who we are, how we are biologically different from other types of animals and so forth, is our ability to process information and draw judgments from it, make conclusions about it, and have opinions about it. So yeah, that's what we do. That's what commentary is. Having an opinion is kind of the opposite of it's kind of the opposite of being biased. Like it's based on information. If I had no information, I'm just like, oh, all people that get charged with crimes are guilty. Yeah, that's a bias. But if I'm like, I've looked at this case and this evidence, and based on that, I think this guy's guilty, that's not being biased. That's being informed. But it's just always a question of being open to new information. So I'm glad you found that helpful. I find it very helpful. The Becca Fly, thank you for covering this, Andrea. You're very welcome. Thank you guys for being here with me to watch it. Carly Steelman, 1659. What's the deal with the AG? I starred this one because I saw it. Why are some thinking they need to be served and others not? Address that real briefly. Utah statute that says if you're going to challenge the constitutionality of Utah law, the AG gets to participate in that. Andrea, what was Bert's question that Graf felt was compelling? Mr. Bert pointed out, he asked if the media requests for electronic coverage would need to be served on them, basically, because what happens, it's one of these requests where it's like a single document that has the request and also the judge's order. And so the practical effect of it is that they submit it, it goes to the judge's desk, he decides if he's going to grant it or deny it, and then, only then does it get filed in the court file. So if they're supposed to just wait for it to pop up on the docket, it's not going to pop up on the docket until it's ruled on. So Mr. Burt is just making the point that we're not even going to know it's there unless they have to serve us. And the judge, I think, didn't realize kind of logistically how that worked. And so it was Stacy Visser who pointed out it's only when the court ultimately files it that we get notice of it, not when it's issued. So yeah, they're going to have to figure out some way to get notice, or they're going to have to file the thing without the order being signed. So it was one of these things that's just a logistical consideration that I think the court maybe wasn't aware of. Good dude, 8767. Will you be responding to any of the conspiracy theories? How will people like Candace Owens impact the case? I don't pay attention to an awful lot that besides what's going on in court. I'm interested in what happens in court. And so if there's a conspiracy, that's a good conspiracy. It's got a good evidentiary basis and it's logical and it's plausible. Then the defense has every reason to bring that into the case, right? They have every incentive to bring in good theories, good grounds for reasonable doubt into the case. And so if there's a good one, it'll find its way into the court process. And then I will talk about it because it will be in the court case. But I don't really, I don't really, there's just, everybody's got different approaches to cases and stuff. My expertise is about what's going on in court. I'm not really following the kind of whodunit stuff and the sleuthing kind of stuff that often happens in the true crime space. This is really not my thing. Maybe some of it will be valid, maybe some of it will not. I don't know. If it is, highly likely it's going to end up in the court process. So that's typically where I wait for things to show up. As far as people like Candace impacting the case, it just depends on her reach. I've said this before, and I'll just repeat it. I think that when those of us who are really interested in a particular topic like this, like a case like this, it's easy to kind of assume that everybody else shares that interest. And it's simply not true. There's a lot of people who don't care at all about criminal cases, who aren't following it closely. There's going to be a massive spectrum there will be people who will have never heard of Charlie Kirk and not know anything about the case. There won't be a lot of those, I wouldn't think, but there's going to be some. There's going to be people that know just generally what happened. He got shot. This guy got arrested and charged. And that's pretty much all that they know. And that's going to be the whole spectrum then all the way down to us. I won't put myself in the super fanatic category because I'm just super fanatic about the court stuff. But then there's, again, there's like all the sleuthing and stuff like that. There's going to be people on the other end of the spectrum who are following absolutely everything and know everything about it. And so, Candace has influence over some of the people who have, greater than probably average interest in the case. What's the effect of that? It might make those people more skeptical, in some ways, might make them better jurors for the defense. I mean, in the sense of the defense is going to want those jurors. Not necessarily, though. There's like a kind of double-edged sword with just having lots of alternative theories because it just sets expectations. If you have an expectation that there's no way, let's just say there's no way that Tyler Robinson or that Charlie Kirk was shot with a 30-06 rifle. There's no way it happened. So there has to be some other explanation for the crime. And that's what you're going to be waiting for. And then if the evidence doesn't support that, if we get a medical report that's like, yeah, there's classic characteristic lead snowstorm pattern. Here's the trajectory of the bullet. Here's what it did. Then that's going to be a real letdown. There's going to be an expectation for like something big, something like a gotcha, something the defense has in their pocket that they're going to be able to whip out and like just destroy the case, have a Perry Mason moment. And those things just don't happen very often. So it cuts both ways. I would tend to expect that just in general, both parties are going to want to avoid potential jurors that know a lot about the case. They want people getting their information from the court process to the extent that they can. So the impact is on the jury pool and on how many people are going to, remain valuable, preferable to both of the sides as jurors. So that's kind of my answer to that. Lazy LCH, I voted no because Andrea thought no. Well, you won't do that again, will you? No, it's good. It's good to show. I'm just, what they say about opinions, everybody, what everybody has along with their opinion. I'm just another person with an opinion, and I definitely don't get it right every time, but maybe I was just a little over hopeful, a little over enthusiastic, letting my interest, my excitement about this hearing taking place and finally getting to see some of these details, fill in the picture a little bit more, let that skew my vision a little bit Does happen sometimes. So sorry to lead you astray there. Oh, well, I guess we will be back then. We'll be back on the 19th. So yeah, it'll be the closing and seal, and we'll get some more filings about that. It sounds like before the hearing happens, because they haven't specified exactly what it is that they want sealed and so forth. So that's going to get filed, and we'll deal with that. And then the main thing, it looks like, frankly, will be the order to show cause. That's the only one that at this point is fully briefed. We can take a quick look at that if you guys are interested. Let me find it real quick. Oops. Oh, there's a loud cat making a lot of noise. Okay. A little tricky for me to get PDFs here, but I'll do it eventually. Okay, is this the right one? Yeah. So this is his OSC. They're going after mainly Chris Ballard, because he's the one that went and made the statements. And then they also want discovery to produce documents and information relating to, the conduct, basically the drafting, the consideration, the discussions about making the statements, the coordination with the media to give the statements and so forth. The defense wants discovery into all of that. They might get it if the judge finds that this is a violation, because it would go to whether it's willful. If they're going to find, so here's kind of how this is going to go. The defense is arguing that Mr. Ballard violated the gag order. Okay, there's the gag order in place. There's specific requirements, and that bars these specific types of things, results of examinations or testing, opinion as to guilt or innocence, and fact that he's been charged with a crime, unless there's a statement explaining that it's merely an accusation and the defendant is presumed innocent unless and until proven guilty. So he made specific statements. Yeah, so they're saying also, the prosecution knows what these limitations are, because they had to send out the notice to all of the law enforcement, all of their witnesses and so forth. We've seen some of these notices. They went like to TPA, TPUSA. They went to the various law enforcement agencies and so forth. And they told them in this notice, don't say these kinds of things. So the defense is arguing like they know perfectly well they're not supposed to be saying these types of things. So here's the statements they don't like. They don't like, first, TMZ. TMZ had published this article. Charlie Kirk murder suspect. Prosecutor slam his claims. Bullet doesn't match. Slam. That's so clickbaity. Oh God, TMZ. Slams his claims. Bullet doesn't match. Attorney Christopher Ballard tells us, generally, when a bullet fragment analysis comes back as inconclusive, that means the fragment did not contain enough detail for the examiner to say one way or the other. There's just not enough there to determine whether the bullet was fired by a particular firearm. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing, and then we will present all of that evidence at the trial. The article further quotes Mr. Ballard. He told us, can't speak about specific evidence, but the evidence that we detailed in the charging document is a general summary of the evidence that shows Tyler Robinson committed this crime. Finally, TMZ states, Ballard added, he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence. The USA Today reported similar comments. I can say generally, he said that the ethical rules prohibit him from speaking publicly about forensic testing and test results, but I can say generally, very clever, generally that when the results of a bullet fragment analysis come back as inconclusive, that means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm. Ballard confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. As soon as the state receives those supplemental reports, we will provide them to the defense, he said. And then he went on Fox News, and PolitiFact quoted him. He said, when the results of a bullet, same thing, comes back inconclusive, this has clearly been workshopped. This public statement has been workshopped. You can tell he's sticking to the same message. He's using the same script. He's talking generally. This is what a inconclusive result means. When the results of a bullet fragment analysis come back as inconclusive, that does not mean that the rifle did not fire the bullet. There just aren't enough marks on the fragment to make a conclusion one way or the other as to whether the bullet fragment was fired by the particular rifle. TMZ, this is like basically the same comments. So that's what the defense is unhappy with. They're arguing that it runs afoul of these 3 provisions of the gag order, things that you're not supposed to talk about that are incorporated. They're part of the ethical rules, but they're incorporated into the gag order. Performance or results of any examination or test, any opinion as to the guilt or innocence of the defendant, or a suspect in a criminal case or proceeding, the fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent unless and until proven guilty. So the state has filed their response, which I will bring up as well. Now let me find it. All right. State has filed their response. Obviously, they don't think that it violates the gag order. That's because they workshopped it to try to keep it within the confines of the gag order. And this is ultimately their point. They're arguing this is fair response. The rules expressly allow lawyers to set the record straight. They don't have to let misinformation persist. They can respond to correct information that, bad information that they didn't cause to be out there in the first place. So they're pointing out, this is kind of the context, was that he says, in the motion to continue the preliminary hearing, the defendant misstated the results of the ATF bullet fragment by stating they were unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. It contains a material omission that it was unable to identify or exclude the bullet as having been fired from the rifle. So they're saying it's misleading. I don't know that this is really it, but I see kind of the point that they're getting at. The ultimate problem here is not, from my perspective, with what the defense said. It's the Daily Mail taking it and running with it and turning it into bullet doesn't match, and that's not the same thing. But yes, the state here is technically correct. It was identified or excluded. So then the media pounced on the incomplete and therefore misleading statement with headlines proclaiming that the recovered bullet did not match the defendant's rifle, that this bombshell finding exonerated defendant, and that this prosecution was therefore fatally flawed. So they got a whole bunch of media inquiries, and in response, they accurately explained the ATF's conclusion, expressed confidence that it had sufficient evidence to move forward and prove its case at trial, and reiterated that defendant is presumed innocent and that the state has the burden to prove its case to the jury beyond a reasonable doubt. Kinda. I mean, yeah, he did say the defendant is presumed innocent in at least that one. Challenge with media is always they don't necessarily report the entire statement that you give them. I don't know if he told every single outlet, TMZ, Politico, Fox News, whoever, everybody that he talked to. I don't know if he told them all Tyler Robinson is presumed innocent. It's the smart thing to do is to have a prepared statement and, just give the prepared statement to everybody. But even giving that out is no guarantee that they're going to print every part of it. So the fact that the defense didn't read it in the news and see it doesn't mean that the prosecution didn't say it. So that's potentially an issue. They say this is the type of response that the Rule 3.6e allows a lawyer to make. The response did not offer an opinion on the defendant's guilt, merely expressing confidence that the state has enough evidence to carry its burden to prove its case. Tells the public nothing more than what the very existence of this prosecution proclaims. I didn't personally see anything in it that I'm like, this is an opinion on guilt. We'll go through this real quick and then we'll look at the defense's reply, and I'll kind of show you. They made a little chart comparing it to this other case where there were like these egregious comments made and how they line up with each other and stuff. So they're saying, here's the problem. Basic background, of course, they said this in their motion, and then, there were media frenzy, the Daily Mail, bullet used to kill Charlie Kirk did not match rifle allegedly used by suspect. And so that was the one that kind of set it all off. It was, blew up, and lots of people said, therefore the prosecution is bad and so forth. Gave way to widespread claims that a bullet analysis exonerates him. But that is not, in fact, what it says. So they also have Marjorie Taylor Greene. So, and then lots of Candace. I mean, there you go to the super chat question as well. How is Candace going to influence this? She's going to end up being, litigated in court stuff if they respond to what she says. So their response, their explanation, they explained the full context of the ATF report. Meaning they're speaking, generally they express confidence that they had sufficient evidence to proceed and prove its case. So 3.6c allows the state to respond. And that's because the rule says, where is it? The lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So, prosecution represents the state, represents the people. They think Tyler Robinson is guilty, that the evidence establishes that. And so if the entire world believes he's been exonerated by, a ballistics or a tool mark comparison, then they're going to have a harder time getting a jury pool and so forth. This is I guess, general idea that it would be prejudicial for this information to be out there, this misimpression to be out there that the rifle was excluded. It's kind of the implication when in fact it was not. So they're arguing that was their justification to be able to respond. And because it's consistent with the ethical rules, it's also consistent with the gag order. What else do they say? Talking about the opinions on guilt are pretty narrow. I mean, there's a fair amount of case law on opinions on guilt because it comes up sometimes in a trial context. You have a witness that just blurts out, I think he's guilty. I think he's lying, stuff like that. Prosecution sometimes argues it in closing, just kind of relies on these cops all thought he was guilty or they wouldn't have sent me the case, kind of stuff. Like you don't get to do that. You don't get to use the weight of your authority and your own opinion to try to put your finger on the scale. It's for the jury to decide your opinion is not relevant and it's inflammatory. So it comes up a lot in case law, but because now we're going to get into cynical black pill mode because the appellate process, the court process tends to be protective of its convictions. It wants to uphold them, and finding, that lots of things constitute opinions on guilt would make it harder for them to do that. They would be sending more cases back down for retrial. They interpret it very, very narrowly. I mean, it really, like, I've briefed this in Washington multiple times, one on it a couple, but usually it requires something really specific. I believe it's, I think you have to be very explicitly saying, I think this guy is guilty. I think this guy is a liar, whatever, using your own authority and not just arguing from the evidence. You might be able to infer that this guy is guilty. Like that's the whole point of the trial. That's the trial process. That's what the jury is supposed to be doing, is drawing that inference from the evidence. So the prosecutor gets to argue that. They just don't get to say you should convict him because I think he's guilty. And so tends to be a pretty narrow thing in that context. And so that's why when I look at the statements that Mr. Ballard made, I don't really see anything that's going to meet the opinion on guilt standard. However, I do think there is potentially a bit of an issue with the testing. Not so much the general, this is generally what it means when there is a ballistics, when there's a finding like this, an inconclusive finding. But the part where he talked about there's additional testing happening and supplemental reports and stuff like that, that's telling about, like, that's describing future testing, and you're not supposed to do that. Now, it's not like the most egregious sin. It's way worse if you're talking about like, oh, and by the way, they did a new test that nobody knows about yet, but it found, this. That would be really bad. It's not that bad. But it's still potentially over the line in terms of what they're supposed to be saying. And then, we think we're going to be able to, the evidence is going to be able to establish he's guilty. I don't necessarily take issue with that. I'm also just not 100% convinced that what they said falls strictly within the letter of what the ethical rules require. They require that you disclose that this is just an accusation and he's entitled to his presumption of innocence. We saw the one time there was a quote that he said he's presumed innocent, but we think we'll be able to overcome that presumption with evidence beyond a reasonable doubt and so forth. I don't know if he said that every time and they didn't report it. I don't know if he only said it that once. Didn't say the part about it's just an accusation. Does he have to? Is it implied? It's a little bit closer. So then here's the reply. Why these things keep coming up. Here's the reply. And so they're just basically saying, we're not in a factual dispute about what the statements were. He admits that he made the statements and, they admit kind of what the statements were. And so based on that, defense is reiterating, they think these things are a problem. So where I'm going to go real specifically here is this exhibit that they attached. This is this chart that they did. So Levitt is this case out of the Supreme Court. It's pretty recent. I want to say it was 2023, 2024, something like that. Might even be sooner. But this was a case, a death penalty case, where the prosecutor, very carefully planned this script, and then got to the press conference and got a question and went completely off script with like, there's all kinds of stuff the public will never see that makes me confident he's going to be guilty. And like, it was bad. It was major train wreck. And it's the most recent and kind of guiding authority on what prosecutors get to say in Utah. So it's what they're using to draw their comparison. The thing is, though, is just that these, whether these statements cross the line or not, they might, but they're nowhere near the ballpark of the statements that were being made by this guy, this Levitt guy. So this is just breaking down. These are factors that the court identified and that says kind of you should look at in deciding whether this is an ethical problem. How experienced is this person? How much attention is this case giving? When was the statement made? Was there a gag order in effect or not? The fact that there's a gag order in effect here makes it a little bit worse. Did you knowingly talk to the press, or was this a situation where like you got overheard or something like that? Like, what's the context of these statements being made? Did you tell somebody that you trusted and then they turned around and backstabbed you and told the press you said it? Those types of things matter. Vouching for the witness. So this witness is credible, and this witness's testimony has been corroborated, is what Levitt said. Here, they say, they're trying to use the generally when it comes back. There aren't enough, and they're adding the information. Trying to use this as a vouching for credibility. No, I don't see that one. I don't see this one at all. This is just a general explanation of what inconclusive means. It's that's already been in public, the fact that they made the inconclusive finding. So this is explaining what it means. This, however, adding information, to the additional reports and so forth, that might be skirting the line. Not so much because it's vouching for credibility, but because it's going to things that are not yet public and going to future testing and stuff like that. The opinion of guilt in Levitt was this: we know things that the jury will never hear. No. How? There was a deputy that was present at this, like a deputy prosecutor who was present at this press conference in the Levitt case. And the facts describe how, like, as soon as he finished the press conference, a deputy is like in a flurry, all freaking out. I'm like, why did you not go across the stage and take this guy down when these words were coming out of his mouth? It's because prosecutors don't have clients. They're not used to managing clients. Any defense attorney, soon as like these words start coming out, you're like, we're used to that. Okay. The client pipes up. Oh, time for the old, the old choke maneuver, whatever. Shut them up at whatever cost. We know things that the jury will never hear, which helps us to believe and strengthen our belief that this man committed this murder. Like, you couldn't possibly make a worse statement. Not only are you explicitly saying it's your opinion, but it's based on stuff nobody's ever going to know. Like, this is just terrible. This is really bad. So unfair and prejudicial. Compared to this, we have ample evidence to demonstrate beyond a reasonable doubt that he committed the murder. We believe we will be able to overcome his presumption of innocence. Not really. I mean, of course, they think they'll be able to prove he's guilty. That's not the same thing as saying, we believe he's guilty, and like that's why people should think he's guilty. They're saying you should think at the end of the day he's guilty because of the evidence. I don't know. I don't see this one as being pretty comparable. And then, you know, steps that they took to deal with it. Levitt, he immediately withdrew, like he knew right off the bat that he bombed. So he got out of the case, conflicted himself out. Mr. Ballard, of course, is still on and still participating. So that's what we're going to be hearing on the 19th. And what they'll be doing procedure-wise. So they talked about this a little bit. What we're doing at this stage, this is a motion for an order to show cause. And so this is kind of like a preliminary showing to the judge that there is a reason to be concerned here. They're not actually having an evidentiary hearing at this point on whether there was contempt and whether any sanctions are going to be imposed. They're basically just deciding, is there enough here to clear that hurdle? It's kind of the same context we were in with the disqualification motion, where, you know, you have to kind of clear this initial hurdle of showing a problem to, you know, then potentially warrant bringing the AG in, you know, that whole like side issue that kind of got brought in. This is a similar type of process. So if the judge looks at all this and thinks, yeah, there's enough here that this could be contempt of the gag order, then he's going to order an evidentiary hearing on it, because then we would need to know things like, you know, did you say other things to the press that didn't get reported, but that would have, like, you know, corrected this? Was any of it taken out of context? Was any of it misquoted? And then they're also going to look at, like, for purposes of, if they find it's contempt and they're going to sanction him, they have to find that it's willful, and they have to know a little bit more about the context to understand, like, what do we need to do to make sure to, like, sanction enough to make sure that this isn't going to happen again. So I think we're probably going to get the hearing, guys. I think we're probably going to get the hearing. I say that even though I think for the most part, like, these are not, you know, again, far from the worst, most egregious statements ever. Certainly nowhere near as bad as the ones that were made in the Levitt case. But still, I think a fair argument that at least some of them do cross the line. There is the fair response. And I think the fair response justifies, it does justify some response to set up to respond to misinformation in the media. I think the state is correct legally that their right to respond isn't just to things the defense says. That's not what the rule says. It just says they can respond to publicity not initiated by themselves. So the fact that the defense didn't necessarily produce the Daily Mail article doesn't mean that the prosecution doesn't get to respond to the Daily Mail article and all of the publicity that surrounded it. So I do tend to agree with the state that there is a right to respond, but I think that might be fairly limited. The question is potentially, in my mind, they can respond to the like bad interpretation of what the ATF results were. They can explain that, generally speaking, here's what that means. I don't take issue with that. I think that's fine. I think where it's crossing the line a little bit more is the you know, there's going to be more evidence, there's going to be more reports, there's going to be more data and stuff like that. Is that really responding to anything? Not real clear. I mean, it's helpful, and we kind of know that from what the documents have said anyway. We know from the court record they're you know, trying to do additional testing on the bullet and stuff like that. But that wasn't really like part of the media story that they're responding to. And so the only other thing that's like really there to respond to is the implication this exonerates him. And so does that open the door for them to say, no, we still, you know, think we're going to be able to prove him guilty and we're going to get new information from the FBI and so forth? I think it's close, guys. It's a close question. So I think Judge Graf is going to kind of treat this like he did with the continuance today. Just the abundance of caution, let the defense make their record and so forth. May not ultimately conclude that it's a violation, or even if he does find it's a violation, he might find, it's not really that egregious. One of the big things that cuts in their favor is that something that always comes up in the context of pretrial publicity is how close are we to trial? Because the closer you are to trial, the more likely that your prospective jurors are going to have it fresh in their minds. They're going to have been exposed to it and stuff like that. We're probably years away from trial still. So very possible the court could decide it's de minimis or something like that. But I do tend to think he's going to do the abundance of caution thing and have the hearing on it and let them make the record about what exactly happened and then deal with it accordingly. So we shall see. But hey, another prediction. We'll see how kind of record I built up on this case. Not so good on the continuance so far, but I like to think I've called some of the other ones pretty well. So that will be the 19th, and we'll wait to see what comes up as far as what the defense wants to seal once it's not to be able to see. I have to imagine they're going to want us to not see the video because that came up before when the state was wanting to use that. They had several videos that they wanted to use and during the motion to disqualify the prosecuting attorney's office because they wanted to try to show, here's all of these people that were present, all of these other witnesses, any, issue with this one witness was meaningless. And the defense didn't want them to be able to do that. Like, no, you can't do that. It's far too prejudicial for that. It's extremely graphic. And I'm sure it is. I mean, even just the, cell phone video that was all over the internet the day he was shot, is not pleasant. It's not real pleasant to watch. And so you got TPUSA, like high def cameras and stuff like that. No, it's going to be extremely graphic. It's going to, that will have an impact on people. So they're not going to want us to see that. I'm pretty sure. But we are in a different context now. Like it's quite a bit more relevant to probable cause at this point. But I don't know, maybe there's not a whole lot of dispute. Like, what is it proving? It's proving that Charlie was shot. I don't know that that's significantly in dispute. Well, I mean, I know that there is a part of the internet where that's in dispute. But I think by and large, like certainly with the defense, I don't get any impression that the defense is disputing that at all. I mean, they've referred to these videos as videos of his shooting and everything. They have the bullet fragment. Like, I don't know that that's really a serious issue in the case itself. So, is it really necessary to show a video to prove that Charlie Kirk got shot? Probably not. You got the medical examiner's report. But there are going to be other issues too in terms of the aggregating circumstance, the endangering other people. That was part of the state's argument. We got to be able to show, there were people behind him that could have been shot, people in front of him that could have been shot, stuff like that. So that may necessitate the video. We'll have to see. They're not going to want us to see it either way. But then as far as anything else, what else are they not going to want? Probably confessions. They're not going to want us to see the Discord chats. They're not going to want us to see the note. They're not going to want us to see, the texts. We've already seen what I assume to be the most pertinent part of the text, but we kind of already know at this point. Like, we knew from the information they had ellipses in the text messages. Like, we know it's not the entire chain. Parts were omitted. And then when the search warrants and the warrant returns came out recently, we also kind of learned from that. There was, like, in the search warrant affidavits, there were some additional parts, of those messages that were included. So a lot of that we've already seen, but there is a total context that so far we haven't. But things like the Discord and stuff like that, they're not going to want that. They're not going to want that to be public. It's extremely like, people tend to think when somebody confesses that you wouldn't do that if you weren't guilty. And a lot of times it's true. It's definitely not always true. But a lot of times it is. It's powerful evidence, very powerful evidence. So the defense is probably not going to want us to see that. Other than that, I don't know. We'll have to see. I mean, I imagine they don't want us to see any of it, but that's not going to be a realistic ask. Maybe they will. I don't know. So we will wait for more defense pleadings on that to spell out exactly what they want to close, what they don't want us to see, and we'll kind of go from there. So with that, guys, I guess we got one more comment here. Lazy LCH. I would almost hope that this prediction was wrong. Your prediction about 2028 was wrong, but I don't see that being wrong. It's going to be wrong in the sense that I said early 2028, but I would take the over on that. That's frankly, I think this is still being pretty ambitious. That would be pretty fast to get a death penalty case to trial. I know it doesn't probably seem like it, but just normal routine cases that don't have the death penalty attached to them can take a couple years to get to trial if they're complicated, if there's lots of evidence, stuff like that. They got a lot to sort through here. They got so much technical stuff to do. We already know there's going to be Daubert challenges. These issues with the DNA technology. Potentially now, we have this issue with the new testing they want to do on the bullet. What's that even? Is this comparative bullet-lead analysis? Have they sorted out kind of the methodological problems, the overstating claim problems that technique previously had that led to it being abandoned? Potentially a challenge to that. This is just the stuff that we know about. They're going to probably want, I don't even know, honestly. They've got a whole mitigation case to prepare. Like it's massive. It's a massive case. They got Discord to go through. The defense is maybe going to want to find people on Discord and, interview them, find out who they are, like all that type of thing. It's good. It could be long. It could be really long. So yeah, I I'm not saying I was like not giving a correct, a good faith answer early 2028, but I am saying if that's where the over under was set, I would pick the over. No question. Far bigger chance, I think, that it's going to be well beyond that than that it would take place before that. It's just kind of the nature of the beast, I'm afraid. So, quick hearing today. Mixed news, but all in all, I think the good part, no categorical ban on the cameras, and so we can probably expect things to go more or less the way that they have been going already. We get the media requests, and the judge has been approving them consistently. The defense is probably going to have to come up with a pretty good reason specific, to the hearing and to the coverage and so forth to justify it. And we'll kind of see how that plays out. How much detail they go into, how much effort they seem to think it warrants to preserve this issue for the record for future appeal in what probably would have to be a federal court situation, since the Utah law is so favorable to the cameras. So guys, that's it for our hearing for today. I'm going to go ahead and check us out now. So I've, of course, had the link up here, the code thing to the brain is a little fried already. The QR code to get to the Substack where I have the archive, the legal documents. So Feel free to keep checking that out. You do not have to pay anything to see the legal documents, although I certainly welcome support. They aren't free, but in fairness, Utah is not super expensive at all in terms of getting records. But they are there. I will be continuing to add to them, so keep an eye on that if that is something you are interested in seeing. I will take the preliminary hearing off my calendar for the 18th, but I will plan to be back on the 19th at 9 o'clock Mountain Time. That will be 8 o'clock my time here on the West Coast to watch the next hearing on the order to show cause and the motion to close things. So I'll do what I typically do and go on a little bit early so that we can take a look at what is going to be on the table for the decision that day. Otherwise, guys, I'm taking a little time off. We're having Mother's Day at our house this weekend, so I got a little prep to do. It's busy time as always. Oh, and one of the downside, okay, just my temporary rant here. I got a brief rant because I live in the West and I love living in the American West. Okay, the West is the best. It's awesome out here, and it has many advantages, but it's very arid. That is not always a bad thing. It has some good things. It means like we don't have a lot of mosquitoes. We don't have a lot of roaches, stuff like that. It's like I go to Florida and it's like, ew, there's like roaches that long. It's horrible. They're like in Waffle House. It's terrible. We don't even have Waffle House here. But the downside of it being arid is that without irrigation, it's hostile to life here, like all life. We are like a moonscape. They call this place the channeled scablands for a reason. And so we just learned that our irrigation system, we're on like an irrigation district here. They're shutting everything off for like 2 weeks. And it's been 90 degrees. It hit like 100 degrees last week. So we're going to fry. And that means I'm going to have to be watering with like a gazillion hoses from my house, moving sprinklers around and stuff like that. It's going to be keeping me very busy until they get the automatic watering back on. So I'm going to be doing a lot of that, but I will make time to continue checking the docket and updating it. And if I get the chance, I will, continue to update with other things. I do have Christy ready to go. Okay, we're about to finish Christy. I do have some more Afro Man just about ready to go. So I've had this stuff kind of on the list. I've been, it's in the hopper as far as working on things, but just haven't quite been ready to put it out yet. But do keep an eye out for that if you're interested in those things I have been doing. Otherwise, yeah, you know what to do. You know where to find me. Find me on Twitter. Find me here. Find me on the Substack. And let me know. Let me know if you got questions and any thoughts you have about where this thing is going. I'm definitely interested in what people think about Mr. Ballard's statements. I mean, obviously, I gave kind of my opinion about it, but I'm kind of interested in the general take. Maybe I'll do a Twitter poll or something like that. If any of you guys are interested in that kind of thing, I'll do a Twitter poll on it because I am interested. Like, this is my reaction to it as the lawyer, but like, what's y'all's non-lawyer reaction? Like, do you think it just should be like a flat out, like, just don't talk to the press? There's a gag where just don't talk to the press, or do you guys like, they have a right to set the record straight, otherwise the misinformation is going to take things over? Like, I'm interested in the, because I think about it from the lawyer standpoint, and that's not necessarily normal. So not necessarily the way normal people think about things. So I am very interested in that. Guys, no skeeters in the tundra. Yeah, no, we're not actually in the tundra. We're shrub steppe. We are shrub steppe is technically our ecology here. Lots of mosquitoes in the tundra. And actually, in the American West, I'm generalizing, right? There's plenty of places in the American West that have enough dampness for some really nasty mosquitoes. There are mosquitoes in Montana, like in Missoula, Montana. They're like the size of a quarter. They will bite you through your blue jeans. These things are so aggressive and terrible. So yeah, like we do have some, but not where I live. Like we don't have that much water here. We're the like 4 to 5 inches of rain a year kind of place. Now Patagonia had almost no mosquitoes. It blew my mind. Like I spent 2 months, hiking in the mountains. I went all the way down to Navarino Island, which is like the, South America version of the tundra. I mean, it's not really tundra, but it's marshy. I mean, there were places we were like wading through mud and stuff. Not a single mosquito. Now they have these horseflies. That are like the size of your thumb. They're called colihuachos. And they're black and they have this big red spot on them. And that's how you can see them. And they swarm. There's hundreds of them. And they're so annoying. Super, super, super annoying. They're not like super painful, but they are really hella annoying. And they bite you constantly. But there were 2 good things about the colihuachos. One was they don't like the shade. They only like it in the sun. And so if you go into the shade, they won't follow you. So you could kind of like, as long as there's a tree around, and there's lots of trees in Chilean Patagonia anyway. Argentina is like a whole different situation. It's more the arid situation, but a lot of Chilean Patagonia is temperate rainforest. So trees, just sit in a tree. But then the other thing was that by like February, they just all die. And then they're gone, and they're not around. So I had like a whole month to 3 weeks going to some awesome places without having to be harassed by the colihuachos. So anyway, just a little common thing apparently along the Pacific West Coast, north and south. Well, not nearly as many mosquitoes as y'all have to deal with east of the Rockies. Anyway, that was a really long aside. So, guys, I got cleaning to do. I got cooking to do. I got my yard to clean up. I got some cats that are squalling for me. I got a dog to walk. I'm going to check out. Thank you so much for joining me. Really appreciate it. Thank you for your support. Keep your eyes on the Substack for the legal documents. And let me know what you think. Let me know what you think about this stuff. I am definitely interested in it and how all this stuff is landing. So we'll be back 19th. It'll be probably 7:30-ish my time, but we'll see. And we'll get that next hearing in, see where things are at, and take it from there. So guys, appreciate all of you. Appreciate you joining me. Appreciate you mods. Thank you mods. Thank you mods for everything that you do. I know the chat gets a little wild sometimes. We do welcome all opinions, provided they are respectful. Just be decent to each other. Don't be assholes. That's like really all we ask. We're not here to like police people's thoughts or moods or anything like that. But we do require that people not be abusive assholes. So don't cross that line, and we won't have any problems. But very much depend on the mods to keep us like free of the spam bots and keep things moving smoothly. So thank you so much for doing that. Really appreciate all of you. Guys, it's been a good one. Appreciate you. I will see you next time.